previous DUI conviction will influence a current case in several ways. The biggest one is if you have a prior DUI conviction and in the current case you have refused to provide to the police a blood, breath, or urine sample when they asked you for one after reading you the implied consent notice. In those cases, Georgia law permits the government to put into evidence in front of the jury the fact of your prior DUI. There's a stated general rule that the government's not supposed to tell juries about prior convictions, but it's a Swiss cheese rule is the truth. But the general rule is you're not supposed to be telling a jury that a person has a prior conviction. They do it all the time, but you're not supposed to. But as far as a prior conviction for a DUI, it wouldn't come in unless you've got a refusal case and you have a prior conviction for a DUI. They will tell the jury about that prior DUI, and that's obviously negative for you. Jury learns you have a conviction for DUI, they're much more likely to find you guilty in the current case. So that's the big one. There are others also. Obviously, the prosecution is going to look at your case very differently, and they're much less likely to want to let you slide, I guess you could say. Further, I think that, well, if the conviction was within the last 10 years, then you will be subject to a different sentencing scheme. Your minimum time in jail will go from 24 hours on a first conviction to 72 hours at least jail time on a second conviction if it's within the last 10 years. DDS will also treat you differently for license suspension purposes. If your last DUI was less than 5 years ago, you'll be dealing with a much more severe license penalty if you're convicted in this current case. So those are the big ones.